a resolution. We believe a resolution is imminent. If the court would allow us a few minutes to complete those discussions, and we don't mind being called back later on as a result of it. But I do believe that we can have a resolution today, and I would just like to see that through if the court would indulge it.
You have the next two cases as well, so we'll handle those two. Again, this is case number 261070LT. We took you all may be seated. We took a recess for Mr. Thomas to negotiate. And where are we at, Mr. Thomas?
Your Honor, I believe the parties have come to a resolution in the form of a consent judgment. I am prepared to read that into record when the court is ready. Just one correction I'd like to be on the record beforehand. When these pleadings were prepared, the information provided to us was that one of the defendant's name was Nick. His name is Nicholas. Okay. I let him know I put that on the record, but that's the only difference in what we have, Your Honor.
All right. Do you want to do so I'll consider that a verbal motion to amend your pleadings, and if you want to just change it on your order, handwritten, I'm all right with that.
Thank you, Your Honor. It's just NICHOLAS. Thank you, Your Honor. I'm now prepared to read the judgment into the record.
All right, go ahead.
Court finds by consent that a valid waiver of rights exists and terms of consent judgment are fair. The plaintiff has a right to recover possession of the property. It is now due to the plaintiff for non-payment of rent and other money due under the lease. Only 2C is filled out, $351.45. That is made up of $195.45 in filing and service fees, $81 in filing fees, and $75 in attorney's fees, for a total of $351.45. Item 4B is checked. The plaintiff can apply for an order evicting the defendant if the defendant does not move out on or before August 1st, 2026. The defendant may be liable for money damage after moving if additional rent is owed or if there is damage to the property. Acceptance of partial payment of the total amount due in item 2D above will not prevent the court from issuing an order evicting the defendant. No money judgment is entered at this time, and both parties have signed the order.
All right, you may approach.
Thank you.
All right, Ms. Mazarang and Mr. Powers, the order that Mr. Thomas read into the record, is that the agreement you made today?
Yes, Your Honor.
And are those your signatures on the bottom of the form?
Yes, Your Honor.
All right. So because you are unrepresented today, you do have 3 business days to decide whether or not you want to follow through with that consent judgment. If you decide that you don't want to, you need to notify the court before the end of that 3rd business day. Now, even though you get 3 days to back out of it, that doesn't change the end date. So you would still be required to move by August 1st if you decided that you were going to follow through with the agreement. Do you understand that? All right. All right, I do find a valid waiver of the rights exists. The parties haven't been advised of MCR 4.201J. I will hereby sign the order. All right, you can get a copy of it at the front window.
Thank you, Your Honor.
Thank you. Parties appear. We are set for a creditor's examination on this matter. A money judgment was entered. I'm sorry, this is case number 2664LT. A money judgment entered in this matter on February 27th in the amount of $3,730. The purpose of the creditor examination is to determine whether or not there are sufficient assets and the ability to pay. I am aware, though, that a small claims has been filed by Ms. Jensen against Ms. Maloney. Was that today that occurred? So that filed today. However, that does not stop the proceeding. So, Ms. Jensen, did you receive from the court, it was probably on a yellow sheet, requesting certain information from you?
No, all I got was this, and I filled out the back of it, but nothing yellow. This is what I was served at TJ Maxx, was these 2 papers.
Bailiff, can I see what she has, please?
That's all I received.
Okay, so that back sheet is the yellow sheet.
Okay.
For whatever reason, it was not yellow for your copy.
Okay.
All right, Ms. Jensen, will you please raise your right hand? Do you solemnly swear or affirm the facts you give today are true to the best of your information, knowledge, and belief? All right, you may put your hand down. So what we're going to do is we're going to have you both go into an attorney room, share the information that you brought, see if there's any way to resolve the case, and if not, we'll bring you back in, and I'll make a determination as to whether or not you should be put up on, one, have the ability to pay in full, or two, be set up on a payment plan.
Okay.
All right. Bailiff, can you take them out to an attorney room, please?
Be her and I.
Yes. It does not necessarily have to be an attorney room. You can do it out in the entryway as well.
Okay, thank you.
70LT. Mr. Thomas appears on behalf of the plaintiff. And are you Haley Masserang and Nick Powers?
Yes.
All right, you may go ahead and have a seat. We are here for a first hearing on a landlord-tenant matter. Mr. Thomas, has there been any resolution to this?
Your Honor, when the case was called, the defendants and I and the plaintiffs were discussing a resolution. We believe a resolution is imminent. If the court would allow us a few minutes to complete those discussions, and we don't mind being called back later on as a result of it. But I do believe that we can have a resolution today, and I would just like to see that through if the court would indulge it.
You have the next two cases as well, so we'll handle those two.
At this point, the judge isn't rushing to issue a ruling. Instead, he's making sure both sides fully understand the agreement before anything becomes official. That's an important part of the process. Every consent judgment must be entered knowingly and voluntarily, especially when one side doesn't have legal representation.
Or are you in the same shape with those two?
In the same shape where it isn't as clear as we don't have one or we do have one. It could be one. I just haven't had the chance to discuss with the defendants to make that determination. That's
Okay.
all.
All right. So what we'll do, since I've got you up here, I'm going to go through your rights with you, and then I'll allow you to go out and continue to talk. So in your packet, you probably got, on us, it's a pink sheet. I assume it's a pink sheet for you. I'm required to go through these with you, so bear with me while I do that. You have the right to an attorney, although this is not something the court would appoint an attorney for. You have the right to proper venue and the right to a jury trial if you request that within a certain amount of time. The right to seek financial assistance and to know that a judgment is not always necessary to get that assistance. The right to resolve the case with mediation if both parties agree. The right to a consent judgment or a conditional dismissal. And any appeal to the circuit court must be taken within 10 days after a judgment in this case. And then on the back of that, it talked about where you could apply for legal advice and financial assistance. All right. So we will pass on this matter and allow you to go back out to continue to talk. And we'll pass on the next two. And,
Thank you, Your Honor.
Yep.
Thank you, Your Honor.
And then I guess that moves us back to Maloney versus.
Yeah. I have a few questions on them, but
Are we close to an agreement then?
Yes.
Do you want to take a moment and discuss those figures? I've got some other cases I can take if you want to step out in the hallway and talk about them.
Yeah.
All right, go ahead and do that. Henniger?
Hi.
All right, this is case number 261087LT. We are here for our first hearing on a landlord-tenant matter. Ms. Henniger, you probably received your advice to rights, or at least I hope you did, but bear with me while I go through those with you. You do have the right to an attorney, although this is not something the court would appoint an attorney for. You have the right to proper venue and the right to a jury trial if you request that within a certain amount of time. The right to seek financial assistance and to know that a judgment is not always necessary to get that assistance. The right to resolve the case with mediation, the right to a consent judgment or a conditional dismissal. Any appeal to the circuit court must be taken within 10 days from a date of judgment in this case. And then on the back of that, it talked about where you could apply for financial assistance or reach out for legal advice. My first question to you, I guess, are you requesting an adjournment for either financial assistance or legal advice?
I am. I did apply with DHS yesterday, so now I'm just waiting to see if I can get any help through them.
All right. Normally I would go out 2 weeks. I don't have 2 weeks available to me, so we'll have to go out to 3 weeks, which would be July 30th. Mr. Gann, what time? I'm sorry, hold on. 2:30? Mr. Gann, at 2:30 on the 30th, would somebody from your office be available?
We will make sure we're there, Your Honor.
All right.
And would that be via Zoom or in person?
You can appear by Zoom, that's fine.
Thank you, sir.
All right, so Ms. Henniger, in a minute, I'm going to send you out to the front window. You'll get your next court date. You're going to need to file a proof of application with the court. You can get that form at the front window as well, and then make sure you get that filed, all right?
And is that just something that I can file while I'm here and give it back?
Yes, if you-
Or just at this front window here?
Oh, I'm sorry. Do you have proof of application with you?
It's on my phone, yeah, I just have to log into my account.
All right, so you'll have to print off that proof
Okay.
and then attach it to the filing.
Okay, and then I can just bring that back up here?
Yes.
Okay, perfect.
All right, anything else for the record?
Ms. Henry, if you don't have an attorney, feel free to contact my office. My phone number is on the paperwork, and maybe we can work something out. If you have an attorney or want to retain an attorney, please have them give me a call, but don't you call.
Thank you.
Thank you.
All right, thank you. You can go to the front window.
This hearing is a reminder that courtroom decisions aren't always about dramatic arguments. Often, they're about making sure everyone understands their rights, their responsibilities, and the consequences of the agreement they choose to sign. Thanks for watching, and subscribe for more real courtroom cases and legal insights.